The presentation has a number of items, but as I was preparing it and after, I found additional information, and some I will do verbally, others I'm going to leave documents behind. These documents belong to you and us. I have all these copies at the office, and now you'll have your copy. So the objective of the presentation is to explain the background of negotiations between 1991 onward. I'm not going to comment on the specific claim. I'm not involved in that. The only thing I will say is in 2006 you submitted your allegations. In 2008 that Canada responded. And since that time there's been ongoing negotiations between the specific claim people and the Mohawk House. The content of the presentation, we'll talk about the history of the purchase of third-party interest to hand to the Gunnetasaki interim land base. Some may find that difficult wording. That's the results of negotiation between the Mohawks and Canada about calling purchase of third-party interest. The reason behind that, the argument made by the Mohawks is we will look stupid in asking Canada to buy land which we consider our own. So the parties mutually agreed to call it third-party interest. We'll talk about the management of properties by Canada with Mohawk advisors. We'll talk about the property management agreement, and I have to thank Amanda for having put the package together. It will be easy to make a quick reference. We'll explain the amended property management and why it came about, what was asked of us, and what we did. We'll talk about the allotment process. There's been a lot of information circulating around the community where a lot of people have different views. I hope that this presentation that we'll do together will help council to better understand and better explain what this was all about. I'm also going to touch on the Xerox small case, which went to court, what had an impact on both government, Mohawk and Irish, to get into the agreement of the land governance agreement as well as the legislation. And I think this is the first time both sides will go through the chronology and better understand why these agreements were negotiated and why it took a special legislation to get it done. And we'll talk about the legislation. We all remember that there was an event in 1990. The government of Canada, the government of Quebec, and the municipal government all got nailed to the wall. The government of today, the government of Canada of today, says this cannot happen anymore. So we are going to sit down, agree on the process, on what we negotiate, how we negotiate it, and it's going to be clear for both sides. And if you remember, 1990, nobody got compromised. So there was a will of the government of the day that a document be produced that would define the subjects to be negotiated. In any land negotiation, whether it's here or any First Nation across the country, land is always an issue. So in the agenda and process for negotiation of March 6, 91, to reflect that spirit, if you go to Article 3, subject matter for negotiation, you see that 3.1I, land issues. You see that the intention of the parties is to get Canada to continue to purchase third-party interests in the Commonwealth land. There's also a commitment to do acquisitions of available third-party interests to be included within the eventual land base of the Mohawks of Ganakasaki. So that was the backdrop to negotiation. Everybody was eager to try. Everybody wanted things to happen. Canada, after the events, wanted to redo its image and negotiate, and the Mohawk leadership at the time wanted to show results. So after it was agreed on the agenda and process, the parties gave themselves a timetable where people expected to have all that negotiated in 2 years. I think both sides were of good faith, but a negotiation, it takes time, you agree, you disagree, so forth. So the two-year mandate went away. Before the mandate went away, everybody wanted to find solutions to problems. The Minister of State of the day, Monique Landry, the government of Canada had a Minister of Indian Affairs, but they also appointed a Minister of State to deal with the Quebec First Nations. Sat down with the municipality, remembers at that time there was 2 municipalities, municipality du Village d'Oka and La Paroisse. So I think both of them were in good faith, and the deal to be made was Canada would purchase a certain number of properties, by memory I think it's 11 or 12, turn them over to the municipality, in the municipality would turn back the fines to Canada, which would be reverted to the Mohawks. Just one thing, this was not discussed at the table and came out on the 6 o'clock news. So at the next meeting, the Mohawk government of the day told us what they thought about that deal, and very strong words, to be polite, and negotiation got interrupted. Then the challenge became to, how do we restart that negotiation? So there was a lot of informal talks between Canada and the Mohawks. The Grand Chief of the day, on behalf of Council, he says, okay, we're going to enter into a MOU between Ganakasaki and Canada, and before I sit down with a chief federal negotiator, you will appoint a mediator, which turned out, some of you may know, Justice Réjean. And before your government of the day came and sat down, there was a number of preconditions that the council wanted dealt with before they came back to the table. By memory, there was housing issues, there was past funding for negotiations that never got covered, and so forth. So on December 19th, 1994, an agreement was reached, And before signing, the Mohawk side of the table said, we want to see the check that you're going to reimburse the negotiations up to date. And my memory was somewhere in the vicinity of 400,000. So before the Grand Chief at the time signed, he wanted the check. And that was a good start. Over time, since 1990 onwards up to 1994, we acquired a certain number of third-party interests. The concern of the day, both for the Council and for Canada, is you're buying third-party interests, there's houses, there's a shortage of housing in the community. How are we going to deal with that? Asking the Sûreté du Québec to do patrols on that in those days was not the wisest thing. So we sat down with the Council and entered into a contract where they would hire 2 Mohawk members who would tour the properties 2 or 3 times a day and to see if they weren't occupied, and also that were pipes frozen, was there vandalism, and so forth. We were getting regular calls, when I say we, Canada, that I want a house, I want to rent. The Grand Chief was bringing to our attention start moving your rear end, because just a question of time that people are going to take over. At the end of the contract, I think the Council had a good feel of the population. They thanked us very much for having passed the contract. Thanked us very much that it created jobs to the community, and did not want to renew their contract. So at the December 1994 meeting, we agreed to continue to purchase third-party interests. And made it very clear that any third-party interest that Canada may acquire will be negotiated at the table. I'm at 2.3, sorry.
So next.
2.3? 2.2. We're at 2.3. And also, at the request of the Council of the day, and we agreed that we had to develop a mechanism to have an orderly transfer. And this, we had a structure of negotiations we agreed to. There was a main table that was composed of the 2 chief negotiators and the co-chairs of the secretarial table. Having lived the 1991 agenda and process, there were so many items to discuss and negotiate, you could not all do it at once. So in order to make progress for both, for us and for you, we cut down the subjects and created sectorial tables. One was land and sinewy, one was police and justice, one was social, one was economic development. Each party appointed a co-chair. The 2 co-chairs would sit down and agree on a work plan, where things were detailed. When all the co-chairs, both sides, had finished their work plan, a meeting of the main table was called, where side by side, the Mohawk co-chair and the Canada co-chair tabled their work plan, and then the chief negotiator would say yea and nay. And once all the work plans had been approved, some were modified and adjusted, each co-chair had to sit down with his counterpart and lay out a budget, how much this was going to cost. The funding aspect was one of the requests for the Mohawk side. They say we have a tough financial situation and you guys only pay us at the end of the year on presentations of invoices. So they wanted a mechanism where budgets would be agreed to at the outset, and money, an advance was made, and subsequent to that, the contribution agreement was adjusted once the agreed upon deliverables happened. And that satisfied everybody. Council also wanted some flexibility. And I think everybody agreed that you may have a work plan. This table may go faster than this one, and this one may be slower. So in terms of funding, they wanted the flexibility, and we agreed to use the surplus of one table to offset any deficit that could occur on another table. And that worked out well all over the years. The next item is just an example to get the people to understand that negotiation wasn't you come to the table today and we discuss this and the next day is something else. So having a work plan agreed to by the parties help. If you take the work plan of the territorial land-based sectorial table, and that's the 203, 205 work plan. Most of the time, except that year, we used to do a 12-month work plan. Then we come to realize that in between the time that the work plan came to the end, some stuff hadn't been accomplished. So we decided to make a work plan a little longer and the funding accordingly. We committed to continue to acquire third-party interests, and an important issue was to discuss the tax status to be given to every new property. New property being what got purchased 1990 onward. It also called for to develop a process, including criteria for the allocations of co-collectors in lands identified in the PMA. And I'll touch on that later, and it will give you the chain of events that brought about the various agreements and the legislation. It was agreed that we would review, revise, and adopt Kaneohe community laws under the LGA and the land governance. I'll touch on later why that was there. We also agreed that we would undertake negotiation towards harmonization. You see, we've put into brackets compatibility. When we sat down with the municipality, there was your lawyers, the municipal lawyers, and the agreement is to be done by these two parties. However, the council of the day asked that Canada sit in on these discussions and be prepared to answer any questions. So one of the lawyers from Justice sat down, and I sat down. And as the discussions went on, there was a fear on both sides with the word harmonization. The municipality was afraid that it's going to give the perception that the municipality and its residents are subject to Mohawk laws and bylaws. Ganatasaki had the exact same preoccupation. They say the word harmonization sucks, and we saw that there was a difficulty for everybody. So we had lots of discussions, and finally everybody agreed that the word compatibility was a better word to be used instead of harmonization. And we all agreed that it meant the same thing as stipulated in the LGA and the legislation. At the December 19 meeting, when we signed off on the MOU, Ganatasaki wanted action right away that as an interim solution, Mohawk residents who had housing problems could have access to these houses. So we agreed that there would be a housing management board that would be composed of 2 representatives from Indian Affairs. In those days, of course, my colleague Monique Gagnon was now retired, and myself. Public Works, some of you may remember Claude Vermette. Claude Vermette was part of the team, and then we, as the council, appoint 2 observers, 2 advisors. Ganatasaki did not want to be officially part of the housing management board because there was limited housing, people would have to develop criteria, and they felt they would be stuck with whatever problems flowed from that, especially trying to have a lease agreement with some of the houses that were already occupied. Our argument was fine, we'll develop criteria, but when someone comes to us and says that I'm married, I have 4 wives and 34 kids, how do we know that's factual? The council agreed to submit advisors, and they would be advisor only. The mandate was to develop criteria objectively, to sign leases, repair and maintenance, and collect rents. The Mohawk side insisted that, and I think Serge, you'll appreciate that when you say you have to draw revenues. They say all the money collected by Canada for the rental of these properties that are rented to Mohawks, when we move on to a more permanent agreement, you will commit to turning over that money to the Mohawk Council, and also any outstanding accounts receivable, you will cede your rights in favor of the Mohawk Council that they can collect that money. Was that an easy sell? Look at the gray hair, it came from there. But at the end of the day, you know, Serge, yesterday you were talking about dialogue, being creative, working together. It was in that spirit that happened. I mean, we understood your point of view. We also understood the limited ways we had to do that. And at the end of the day, we turned over the money and turned over the accounts receivable. There was many ways of doing that. Turning over the money of rent collected was easy, but getting the Crown to relinquish a debt owed to him, to somebody else, Next time it happens, I'll bring you along. It takes a lot of talking, it takes a lot of lawyers, and we wanted something simple. Let's make an agreement that says there's so much account receivable and we're turning them over to council. Justice was at the view that these were considered individual debt. So therefore, we ended up with a pretty big document that listed who owed what, in order for us to be able to see all these outstanding money to the council. Both the council and Canada came to the conclusion that it was always important to keep the community informed. So when we created the Housing Management Board, a letter was sent to all community members, sent by Canada, and explaining that this was unfolding, who was going to be part of it, what we were going to do. We made it clear who was the management board and that there were Mohawk advisor. We entered into meeting in, once we established criteria, the Mohawk advisors informed us that how are you going to establish the rent? Because there was big houses, small houses, and brought to our attention that the socioeconomic situation of the community, not everybody could pay high rents. So we had a couple of brainstorming sessions, and we're stuck at our end with directives and instruction. You take the value of the property, multiply by this and that, and that wasn't adequate. So we developed a formula that permitted to give lower rent rates. They varied as low as $100, and I think the highest was $400 a month. And we continued, Canada, to maintain and repair the houses. Negotiation progressed, and in parallel to the negotiation on how we deal with the houses and so forth, there was negotiations on the bigger picture of the seigneurie and the land table. We had a number of properties purchased. We had a number of residents who had a lease, and there was a number of residents that didn't want to sign a lease and therefore didn't want to pay rent. We had people who signed the lease, paid 1 and 2 months, and then stopped paying. And we were stuck with, do we continue to purchase third-party interests when we know that there's a strong chances that somebody will take them over? So we sat down with the council and said, well, how do we do that? And there was a lot of discussions, and none of us on our side could put the finger what the problem was. Especially it was in the spirit of the MOU and the agenda and process. The Grand Chief of the day, I sat down with him and I say, hey, tell me what's wrong. His response was, I'll tell you what's wrong. And last night I said, you guys always make a difference between who you represent and the individual. He started the conversation by saying, Walter, don't take this personally. But if council gets into an agreement to take over the full management of these properties, you guys are going to walk from the table, and the rest of the issues are not going to get resolved. Okay, once you know what the problem is, you can start dealing with it. Everybody acknowledged on both sides of the table that the Mohawk government has to take over some of that. So the brainstorming, which was interesting, Mohawk representatives, Indian Affairs representatives, lawyers on both sides, and it was decided and agreed to that the parties agreed that a non-profit corporation would be, a Mohawk non-profit corporation would be set up, which was a KODC. And Canada would do a simple business contract with the corporation. Therefore, there was also a concern on the Mohawk negotiating team. They felt that if the council signed the agreement to manage the properties, they would get a lot of political flack from community members who may accuse them of, you sold down the seigneury for a couple of houses. And that was a deep concern. And we took that into consideration. When we were ready to conclude the property management agreement, I'll cut up the part. There was a first version, a second version, you modified it, we modified it, and when the negotiators agreed, well, you had to put it to your lawyers, we had it to put it to our lawyers, then the lawyers spoke, and at the end of the day, everybody agreed. The council agreed that that was a viable option, but they also said, well, Canada created this problem, so we're going to fix it together, but you're going to pay the bill. So we agreed on the terms of reference, that how the properties would be managed by KODC. We paid $280,000 for the operation of KODC, personnel, staff, and a bunch of other things. Before the property management agreement was signed, Galatasaray wanted that we would get an impartial person to go tour all the houses and establish house by house what repairs would have to be done and what it was going to cost. It ended up, and you'll see weird figures, and you may ask, well, why 497 and not 500 or 4? The request was somebody does an independent evaluation, and whatever that price tag is, we pay. So at the time, there was 200,000 for minor repairs, 497 for major repairs. We turned over the accounts receivable, 479,000. We had collected 270,000 in rent, and that was turned over. Over the years, many people and subsequent councils told us this was a sneaky deal. It was done behind closed door. Nobody was aware. Both sides of the table knew that was not true. So prior to signing the property management agreement, KODC, Mohawk Council and Canada sent a newsletter to the community, independent newsletter. The spirit and the facts were fairly accurate, but then council wanted to make political statements. That's fine, they did, and us too. And in the documents Amanda has prepared, the exchange of letters and all of that is there. For this council, who may also be accused that you bought into this sleazy deal that was done behind a closed door, I will turn over the signing ceremony. The Mohawks wanted that this agreement be signed on Mohawk territory and in their office, and not somewhere in Montreal or Quebec City. We agreed, and this picture is and nobody is allowed to laugh on how I looked on that picture. That's strictly, forget, maybe dusting around. And the second picture is anybody who argues the check was not given. It's a picture of the Canada's chief negotiator, and Solis, who at that time was chairperson of KOBC. And the rest of the pictures is people signing, and what I would like council to notice is the atmosphere. And you will see everybody smiling, everybody's kidding everybody, and there's a sense that we have accomplished an important first step. The last picture self I'll give to you. I had committed to give that to Hans. So give it to Stanley.
You changed a lot there, Walter.
I know. I was good looking and young. And the lesson for that is when a commitment is made, it gets honored, sometimes late, but it gets honored. As the land governance negotiations were unfolding, the property management agreement was coming to an end. When we did the original property management agreement, the parties agreed that you don't control the pace of negotiation sometimes. Let's keep ourselves some maneuvering room. And we put a clause there that upon mutual consent, the agreement can be amended. Another concern was brought up to our attention is the council of today said we're starting to create two types of citizens. Those who are occupying land prior to 1990 and those occupying lands and buildings post-1990. And there was a genuine concern. Some people were paying rent, maintaining their houses, had been living there for a certain amount of time, but were they to die, whatever they want to do, they could not will their property, wife, husband, children. So we were asked to find a way how the 1990 properties onward, where there was a way that OCA letters be issued. And using the format, council at the end of the day makes a recommendation and the OCA letter is put out. When we signed the amendment, money issues came up, and we paid for the operating costs and the major repairs that were left to be done. Getting a way to amend the property management agreement to include a process of some sort that OCA letters would be issued was not a not an easy task. So for us, what was important is that it be a fair and open process, and that consideration be given right of first refusal to people who had signed the lease with the corporation and had been a tenant in good standings. And that we had to deal with a time frame. It was Ganatasaki who determined the time frames and put steps. And fine, we agreed, we signed off, and there again, on this one, in amending the property management agreement, and since we were going into Oka letter allotment, the amended agreement had to be signed, KODC and council, because KODC did not have the power or the authority to recommend the issuance of Oka letter to the government of Canada. There again, communication was important. We put out a letter, council put out a letter, and KODC put out a letter. If you go to the amended property management agreement, 3.1 lays out the steps, A, B, and C, and so forth, how the process will unfold with dates for the issuance of Oka letter. Politics is politics in your world and in my world. So we ended up, before having all this done, in an election in your community. The incoming government repudiated all the agreements that had been signed by the previous council. LGA, PMA appointed, amended PMA, and we're stuck with that. There's obligations on both sides of the table. So we engage a dialogue with the new council, brought them up to speed, registered their arguments at the behind closed door and all of that. And we said, no, that's not the case, produced the documents. And then it was a binding agreement on both sides. The Mohawks had things to do, we had things to do, but we could not do what we want to do until the Mohawks delivered on what they had committed. And as of today, the Oka letter issue has not been resolved. When we came to the conclusion that it wasn't happening, we felt we had a commitment to the people occupying these properties who have paid rent. So a letter was sent to the occupants by the highest authority in the region at the time, which was Jérôme Lapierre, who was the RDG. Very factual, explaining what was in the agreement, what commitments were, and using the mildest language possible, saying that as of this date, this hasn't been done, and stressing the fact that we had a duty to inform the people of what was unfolding. There was a couple of attempts subsequent to that, and other council is how do we deal with that issue of old collectors? There's one clause in the agreement who comes difficult to enforce, is the notion of right of first refusal to a tenant in good standing. Well, when the amended agreement came to an end, a decision was taken by the government of the day on your side that KODC said, no, our mandate's over, we're not collecting rents, we're not signing lease. And the council of the day took the position, that's it, that's all. Where we are today is these houses are there, some are in good shape, some are in bad shape. But the council is not in a position, and we're not in a position to issue old collectors. What's important for us, based on the agreement, is that you submit a process that's fair and open. The clause about the right of first refusal, should we re-enter discussions on that topic, I'd be prepared to recommend that we strike that one off. But before you recommend the allotment of old collector, the agreement says we have to see the process, that it's fair and open. One of your lawyers at the time who worked on that is Dave Schultz. And the concern of the council of today was, say we do this, what prevents the next council to revert that for all sorts of reasons? So he felt that one way to deal with that, since you had the powers to make laws, he would put in a Mohawk law what the process was going to be. And in the Governance Act, there's a process, how you enact your legislation. It's got to be approved by the community. And he felt that this would be a protection, because any council who would want to undo what that council had done would have to go back to the people. That effort died in the process. In those days, Serge, it was an open relationship where both sides of the table shared their concerns. Council would say, I'm stuck with that, and we would say, fine, we're stuck with that. And there was not of informal, without prejudice discussions where we would brainstorm, and try to find the best possible solution for Canada, the council, and not forgetting for the interests of the community members. So that was an effort made by your lawyer. I think you have included in the package that...
I believe I may have included that in the...
And it's worthwhile reading. It was an idea that came on your side of the table. It's not up to us to decide if you send us a process, which is a simple process that meets the standards, or you say, well, we've decided to legislate on that. That's your call.
Am I on the right page?
I'm on 13.
Holy crow.
I do this by memory. I've done the presentation a couple of times, and I sort of get carried into the actual facts, how they unfolded. Haven't been in that.
You were supposed to nudge me next.
Eh?
You were supposed to nudge me next.
Yeah.
Are you
I beg
taking
forgiveness.
any questions or comments at this point?
Yeah.
Yeah? All right, well, you touched on so many things. One of the major problems that you had from the very, very beginning, was being in one of those federal homes myself. I wanted to pay the rent, but I also wanted the option to buy the house. it was ironically Clarence Simon who said, "Don't you give them nothing." He says, "You're a Mohawk, you're a..." Oh yeah, he even said it in a public meeting at one point.
If you look at the picture, and with all due respect
Yes.
to Clarence, as an elected official and a friend, he was one of the signatories to the agreement
Mhm.
and the amended agreement for the process.
This was before he got in office. This was under Jerry Pelletier at the time. And at the time,
No, the, Jerry was there on the MOU of '94.
yes,
And the Housing Management Board.
yes. The
It-
point,
It
yes.
was James, who was Grand Chief
Mhm.
on the
Yes.
property management, and it's another.
I remember. Jerry was there when these houses were being purchased.
Exactly.
The details were being negotiated. A lot of people back in that day, Jerry, there was a lot of violence in the community, a lot of shooting, a lot of,
I know.
you
I
remember
think your
that?
house got shot up.
Well, anyways, there was a lot of shooting back and forth, let's
Yeah.
put it that way. It was a sad time in our community's history. And what was seen was Jerry actually taking advantage of those situations to keep political opposition in check. Take, for example, using the council, he sent a letter to one of the elders for a cease and desist to stop talking badly about him, or he was gonna sue her. He sent this to an elder. We saw some of these individuals who were responsible for the violence block the road up in the Pines, and Jerry going in front of them, inspecting them like his troops. So
Yeah, I
that,
remember that one too.
you remember that. And then when James took over, when he came in, I was a real supporter of Jimmy, and I understood why he had to do the things he did. As a matter of fact, when the LGA passed with +2 votes, I even saw him at the band office and I told him, "Look, Jimmy, you let this pass by 2 votes, you're gonna pay one hell of a political price." I said, "You gotta be careful with this thing." And unfortunately, I was right, because years later, his house would get burned down and his family was threatened. And that was really unfortunate and really uncalled for. Now, with the houses and KODC and so on, there was a lot of perception at the time, not just from me. Many people saw the corruption that certain people were getting the repairs while others who desperately needed it were ignored. There was also the perception in the community at the time, because of the violence, that people could not voice their opposition properly, and there was a lot. I was one of them. I hesitated going to public meetings because we had these individuals at the back of the room pointing like pretend guns at people like this and targeting them. So again, that really limited people's ability to voice any discontent that they might have had, or try to ask questions to get clarification on things, what council is doing. And then the other perception, again, and I brought this to you before, that council after council since 1990 has had no checks and balances, where the community feels that it is indeed their council and that the people are in charge of that council. Sometimes public meetings weren't held for like 6 months, a year, no public meetings, instead of holding them regularly. Councils would hide behind their closed doors at the office and not want to face anybody. So that adds to the perception that council does not indeed belong to the people. They have these deals that were being done with Ottawa. There was no mechanism in place to consult, and like today you have the consultant accommodation type thing. Well, today there still really isn't anything in place like a consultation process under which we would make the decisions, what goes to a secret ballot, what goes to a show of hands, what goes to just mere consultation. We don't have anything that's clarified on that, and we're working on that right now. So, no checks and balances, like the hereditary system, as imperfect as it might be, there were clan mothers watching the chiefs, making sure that they remained as straight as possible. There were problems with that. And it was even worse when this elective system came in. So we've been facing that. That's why you've seen the divisions, one council after another, because they were allowed to get away with it. You talk about all these things here. I'll tell you, there's a lot of people that wanted to purchase the homes. They wanted to have some certainty in their lives, but that was denied. I remember Dean Gabriel at the time, I asked him that same question, and he says, nope, not gonna happen. It's like, no, you're gonna pay to the corporation. I'm gonna pay the corporation. No, I'm not. No, because you do not work for the people, you're a corporation, you know, just working for the, basically the council. That's what the perception was. So you're talking about a lot of history, but below what you're presenting in black and white does not reflect the reality on the ground at the time. The oppression that was going on, the dysfunction that's plagued our council since 1990 has led to all these problems that we see today. Whether you're talking federal homes, you're talking the apple orchard, you're talking economic development in any way. So we have a lot of work to do just to sort that out.
I said earlier, for us, the importance of keeping the council and the community informed. When we set up the management board, when we did, the first PMA and the amended PMA, we made sure, we suggested to the Mohawk side, we are going to set out the letter, and you're working in partnership, here's a draft, what's it going to look like? Changes, minor changes were made at the request. We said it was up to KODC and MCK to put out what they wanted. We were not going to comment that. But we felt it was important that we get council's input on the letters we were putting out. We were aware, when we say aware, community members in those days and still today call you and express what their concerns are. If it's an Indian affair concern or another federal department, we deal with it. But when the concern is about the council staff, we hear them out, and the only answer is, we say, well, fine, I've heard your problem. The solution is with the council or whatever staff. And then, well, we don't get compliments, we're told that go fuck yourself. And there's a fine line that we cannot cross, is we cannot take decisions for council, and we cannot impose on council how to run their business. And we have to deal with whatever council is in front of us. Did we prefer to deal with this council as opposed to that council? Probably, but at the end of the day, we have to treat each council, respect,
Of course.
and try as best as possible to do things that will help the community.
But the point I was trying to make, Walter, was that in this presentation, you're showing us pictures, you're talking about the details between you and the council.
Various councils.
Okay, looking at it, oh, it looks so easy, it looks so harmonious, everybody agreed. But I'm just saying that the reality on the ground, what we lived through, that's not really what it was all about with us, okay? And sometimes the perception in the community was that the federal government kept financing these councils to do what they were doing. And I understand, don't worry, I understand what your responsibilities are. But in the community, it's like, well, Ottawa's financing this bunch of crooks. these
Yeah.
people, these very people who are suppressing us in the community. And I know that there were a lot of complaints made at the federal department by people about one thing or another, what council was doing or wasn't doing, about the violence in the community, the fear people had for their children and for their own well-being. It was not that easy. I look at these pictures, everybody's smiling. Oh, it was nice, the handing of the checks. But in the meantime, people are getting shot at. And during this time, or shortly after this signing, shortly before this signing, there were major fields of marijuana being harvested.
1995.
1996
Five.
was 96, I'm sure. No?
95.
What was 96? Anyway, there were so many years that, so many issues happened in the community.
I remember 1995 and
Yeah.
all the pot fields, because what the news were running is major pot fields on federal land.
Mm. Yeah, so these were all the issues that people had to face here on a daily basis. And it was just a sad time that it seemed like the federal government was almost like partners with the council. That, I know that's not the case, okay, but the perception,
We have to
It-
deal with
it was difficult.
whoever the community selects as their leaders.
Yeah.
I worked with the former Six Nation traditional hereditary chief. People decided another form of government.
Mm.
Had a very good relation with the Six Nation traditional hereditary chief. A new council comes on board. Whether we like it or not, we have the legal obligation to deal with it.
Absolutely. That's understood.
You raised up an interesting question about wanting to purchase
Yes.
the house. The reason we did the amendment was twofold. One, it was that the people in the community, no matter what house they occupied, could have a no collector.
Mhm.
The idea behind that was council would put a price tag of X dollar. We said, it's your decision. You want to sell them for $1, $100,000? There was discussions, how and how much do we sell them? We said, that's your reason. We're not going to comment on that. The only thing we're gonna comment on is the process.
Mhm.
And in those discussions, it was brought up that some community members wanted to purchase. We said, that's fine, you deal with it. And the idea behind that was twofold. The monies that would come out of that could be used for housing all over the interim land base, and some could be invested in economic development. When we did the property management agreement, there was 11,000 apple trees beside the Monjean farm there. I think it was Binetou, I forget the name.
No, Monroe.
Monjean,
Yeah.
yeah, okay. And when
No,
we
Moreau.
did.
Moreau.
Moreau, yeah, Moreau and Mongeon was the farm
Yeah.
next to
Yeah.
it.
When we did the agreement, council and KODC made a good pitch. They said, we're going to be stuck with these 11,000 apple trees. We need funding for this, for that, for this, for that. And we said, fine, submit us a plan. They did, and we provided the money. That's all we can do. That a legitimate concern was raised. We said, yeah, submit the price tag. And we said, fine, that's the price tag, good. We looked at the figures, they made sense. And we said, fine, we'll include the money in the agreement.
Mm.
And I share your view that maybe the information didn't get out as it should have. At our end, we did due diligence and we put out the information we could put out, and any communication we put out to the community, we send a copy to the council. And that was our responsibility. Were we aware of the various issues that were unfolding in the territory? Yeah. We got all sorts of calls on the security issue, and it was in the agenda and process. You wanted your own police force. We got into that negotiations with the intention of providing the council with a police force, because in all fairness, the SQ were riding quick to the territory and they weren't actually police.
Well, as they are today.
Yeah.
Today, I'll give you an example back then, another example about how bad it was. When they were doing the consultations for the LGA, I was invited to give my opinion, but I was afraid for my family's safety at the time. So I made arrangements to meet with Brenda and Angeli Chokski in Senastash to sit down with them, because I feared that if I was seen talking with them, that I would get further reprisals. I don't care about me, but my children, my wife. So that's the kind of mentality that people had to adopt here. They had to keep their heads down while everybody else was doing one thing or another in the community. There was, like I said, pot fields and there were other things at the
Other
time.
types of activities.
Exactly. So that's the mentality I had to adopt. Be careful. And you couldn't walk down the streets even today. My kids walk down the street and I'm terrified that someone is going to target them. I do not keep pictures of my children in my office because I don't want people knowing what they look like.
You don't want them to
Even
target.
today. That's the reality here. So when I see pictures of everyone smiling and signing checks, I'm sorry, but it pisses the hell out of me. And
But from our perspective, Sam, we were asked to do things from the governing body of today. The
Yeah.
security issue was an issue that was brought to our attention. And what we were told at the time by council, the only way we're going to get decent policing is if we have our own police force.
mhm.
It was part of the items to be negotiated. I think we did 3 agreements and 2 or 3 extensions. I know how this ended, but from our point of view, First Nation comes to us and they were saying exactly what you're saying, Sam. This is the Wild West. At one point in time in the Terrace Raymond, somebody called me and they said, oh, we don't call that Terrace Raymond, Walter. We call it Little Kigali because there's a war zone going around that. So
I think the name was Little Saigon
Or a
or,
West Beirut or something like that when it's when.
I don't know, yeah.
But I mean, we're getting this information, and then the council of today pulls out the agenda and process of 91 and 94 and says, we need our own police force. Entered into negotiation, then the public security people, Canada and Quebec, they have their little book and it's 1 police officer for so many people. The reaction on the Mohawk side was, okay, I think at the time, based on the standards, you would have got, I think it's 4 police officers. The argument was made that even though that was the standard, knowing the level of activity in the territory, there's no way 4 police officers would be able to handle it. And that's the argument that was made, and some of us bought into it.
Mhm.
They said, so okay, we have 4 police officers, we want 24-hour policing, so are you telling me that 2 officers will work for 12 hours and the other 2 officers will work for 2 hours, and there's no way we're going to send one police officer. It went on, and argument was made, and I think we agreed on 12 police officers and a chief of police. Our duty and our responsibility was to provide the council with the means and ways. The means and ways we had was sign an agreement, pay a check. And there was concerns at the time, and I think you've raised it too, is the police force has to be independent. That's why in the agreement, we provided for a police commission. And it worked for a while, but comes a new government, a new commission. All we could do is deal with, in good faith, with our partners across the table.
Yeah.
And in the first agreement, we hit a snag, where is to determine where Mohawk police would have jurisdiction. The challenge says was that if you look at the checkerboard land list, Mohawk, non-Mohawk, what police has jurisdiction on one piece of land? You start chasing a guy on the Mohawk lot, he goes on the non-Mohawk lot. When I say people got creative, we say, okay, we drew a patrol zone, which included Rang Sainte-Sophie, all the way down, and all the territory over here. And in the agreement, there was a protocol between the SQ and the Mohawk police that in the patrol zone, first police of intervention is Mohawk, backup is SQ. And where the stick was is Quebec was not prepared to have the police force to have jurisdiction on the 57 lots. That was tough. Creativity again, it was agreed that in the 57 Mohawk lots in the village, the SQ would have the prime responsibility, but the Mohawk police would be backup. And says, I don't want to run down the SQ. We all knew the stories that the minute something would be happening in the village on the Mohawk lot, the SQ would call. So it's a three-way negotiation. So we had to find a way to have a police force. What was suggested by the Mohawks and agreed. We agreed to the police zone. We will agree to this arrangement, two conditions. We call this policing agreement an interim agreement, and both governments are going to commit in the next round of negotiation. The 57 lots are in the agreement. And the way the agreements were made at the time, there was no funding for a police station. The agreement provided for a certain amount of money that you could rent facilities. So, good argument made by the Mohawks. Okay, let's go tour the territory and tell me where the hell we're going to have a police station, what facility we could rent. So, condition was put to the signing of the agreement. By your side is, we're prepared to sign interim. Next agreement, the lots in the village are included, and we want a real police station.
Mhm.
That's what was asked. Did we have to be creative to fund a police station? Yeah. But at the end of the day, we felt that the demands were legitimate. We honored them. And it's sad because the same police station there is going to be bulldozed. But we are limited in what we can do. And we assume our responsibilities, but our partners on the other side have to do the same. And our actions as bureaucrat negotiators is judged by our government. You're good, you get a tap in the back. You're not good, you may want to find a job somewhere else. On your side, every 3 years, the community gives you your report card. They re-elect you and they say goodbye.
Exactly.
And we cannot get involved in the politics.
I understand.
Yeah.
Fact is, yeah, the police station is going to be torn down. I don't see it as necessarily a bad thing. I think it's a fitting end to a very sad period of our history. It's like, okay, you got all this work on a blackboard. Well, it didn't work out. You have to erase it and you gotta start over. That's the case with the police force. Now, the mistake that was made, I've always observed back then, was that the police force came in, and boy, they came in full force. They started taking actions against targeting certain individuals. I understand why. I think the best, a cautious approach would have been 6 months there, just take it easy. Just patrol the community, get to know it, keep some of the peace. Only act whenever necessary. Don't go looking for it. Just leave it be, and then assert slowly but surely. But you said the police commission, and the police commission again was, I guess was, what would you call it there, susceptible to political meddling, okay? Like you said yourself, next council comes in, the commission changes. That's no way to operate. Because again, you're politicizing not only the police force, you're also politicizing the commission itself. So there has to be a different way of doing that. And that's what we're going to figure out, if we ever get there again.
The campaign, we act. When I say we, it's coming to them. When you make an agreement, the body you make the agreement with is the council.
Yes.
Whether it's here, Ganawaki, Akwesasne, or any other First Nation.
Of course.
And by the agreements of these days, and I don't know if they've changed, the identified employee is the council.
Mhm.
That's the rules, that's what we did, and I think we did it in good faith and addressing what was a legitimate concern of the council of the day. Earlier in the presentation, I mentioned that the Jean-Luc Simon case was one of the elements who brought both the Mohawk Council and Canada to deal with the issue. I'm going to give you a couple of highlights why it ended up in court and why it put the onus on Canada and the council to deal the issue, and that's what brought about the LGA and the legislation. The Jean-Luc Simon case is Jean-Luc was building a 3-story apartment building on one of the Mohawk lots in the village. Jean-Luc had applied to another federal department at the time, NEDP, to get funding. Jean-Luc's concern and the other federal department's concern was, do municipal bylaws apply on Mohawk lands in the village? Between federal departments, we share information. Our legal advisors told the other department, now this is federal land, bylaws don't apply. Jean-Luc started his building, and at the time in that area, in the municipality, you cannot build more than a building 2 stories. Jean-Luc was 3. So the municipality sought and got an injunction for Jean Roch to stop building and rule that in favor of the municipality that the bylaws did apply to Mohawk lots in the village. Jean Roch and council appealed the decision of the Court of Appeal. And following arguments were made by the Mohawk. And before I retire, I'll send you a copy of the Jean-Luc Simon decision. So, at the Court of Appeal, council, before I went to the Court of Appeal, council came to us and for funding. We had a program at the time called test case funding. It kicked in only on cases that were at the appeal stage, and there was an interest that could affect Canada. So proposition was made, and the program at the time paid 80% of the bill. At the Court of Appeal, the Mohawk lawyer argued that the lots in the village and the rest of Mohawk lands, even though Canada had not passed an order in council to declare them 9124 lands, they had always treated them as such. Canada took the position and told the court, you don't have to take a position if these lands are 9124 or not. They are at minimum 91 1A lands, which is federal, public federal lands, and therefore your bylaw, the municipal bylaws don't apply. Your lawyer is happy, and they're happy that Canada is standing behind. Court of Appeal took and I'm not a lawyer, but took a decision that nobody was anticipating. The Court of Appeal ruled that the activity of Monsieur Simon, they couldn't see their term, the Indianness of the activity. They turned to Canada, and you know, it's an apartment building going up on federal lot. I don't see that as being public land, because the activity is not there. And it came up with the following ruling. They walked on the line and rendered a decision that said, the Mohawk Council has not exercised its jurisdiction on that lot, which is factual. You were not an Indian reserve, therefore you did not have bylaw making powers. And he said, as for Canada, you neither haven't exercised your jurisdiction to regulate that piece of land. Therefore, and this is important, until such a time as the Mohawks or Canada exercise their jurisdiction on that piece of land, I cannot have a lot in the middle of the village where there's a legal vacuum. So until you guys or us guys exercise our jurisdiction, municipal bylaws apply. The good part of the judgment, to the extent there's a good part, is he limited his decision to Jean Roc's lot. Didn't touch on the other lots. Council came to us and they say, we want to go to the Supreme Court. Okay. If we have Canada's support when we seek permission to the Supreme Court, our chances are better. The judgment also said that Jean Roch had 90 days to tear down his building. And on top of that, he had to go to the municipality to get a permit to do that. And if in 90 days he had not complied with the judgment, the municipality was given permission to bring the building down and send a bill to Jean Roch. Unfortunately, Jean Roch is dead, but those of us who dealt with Jean Roch, he's pretty strong-minded. So we agreed to support the council to appeal at the Supreme Court. We also sat down with the council and says, fine, the court may hear you, they may not hear you. We're still stuck with the building and the court book. So we supported the Mohawks and Jean Roch to appeal at the Supreme Court. Supreme Court does not have to justify why it hears you or why it doesn't hear you. So the judgment came out and said, thank you very much, such a case, bang, bang, we're not hearing you. So once again, Canada, the council, and Jean Roch sat down and we were stuck with this issue. Supreme Court don't want to hear the case, and we know on our side that neither the council, neither Jean Roch is going to go to the municipality and ask for a permit. We focused on the jurisdiction issue, and we said, okay, these are Mohawk lands. We recognize they haven't got a 9124 status, so what do we choose? Do we give the authority to the council to exercise its jurisdiction, or does Canada exercise its jurisdiction? From Canada, it was a no-go. So we sat down with Jean Roch, your lawyers, our lawyers, and said, okay, how do we fix this within 90 days? And that's when you were talking yesterday, the partnership, the creative thinking. Everybody's in a mess on the Mohawk side and our side. Biggest challenge for us was that how does the building come down? And Jean Roch had invested 50,000 of his money. He had got a grant, I think it was for 240 or 242,000, with a clause that said, if you don't go ahead with the project, you turn the money back. So after everybody negotiated in good faith and where everybody came out win-win, we sat down with Jean Roch, and Jean Roch made a valid argument. I was told by your department that municipal bylaws don't apply. I say, fine. The court decided otherwise. And I'm not going to bring my building down, and I'm not going to go get it done. Long story short, we found a way to reimburse Jean Roch. We sat down with the other federal department, explained the story, and we say, write off that debt. And Canada didn't want us to get a permit from the municipality to turn it down. Two reasons: we're a higher government. The second reason, it would be an insult to the Mohawks. So we contracted the demolition, passed a contract with the contractor in which we put a clause which said something like, it is incumbent upon you to go get all the required permits. So at the end of the day, Jean Roch recuperated his money, the debt got written off, the building came down, neither the council or Canada asked for a permit. And that was a happy ending. Once that went through, we said we have to fix the jurisdiction issue. So based on the agreement of 91 and, 94, was there sufficient tools for us to do something? And if you go back to the 94 MOU, the notion that you want a 9124 status, you stayed away from calling it an Indian reserve, that gave us the leeway to fix the jurisdiction issue. So that's how the land governments got agreed. The two important issues in the legislation was the status of the land and the legislative power and bylaw powers the council would have on a number of issues. And that to date has paid off, and I'll explain. You have powers to make laws and bylaws in environment, health, protection and management of wildlife, trespass, fire safety and protection services, residency, construction and maintenance of local work, construction and regulation of water supplies, building constructions including inspections and renovations, water disposal, management and sanitation, traffic regulation, public safety. And some of your arguments were made. They said, okay, we're going to have all these powers. Who's going to rule on it? We included the power for council and the process how to appoint justice of the peace. So the land governance agreement was moving forward. And once both parties were satisfied that everybody's objective was met, everybody stressed the importance that the community be informed. Council put together a team, asked for funding for the consultation process. That unfolded, and as Brenda was saying yesterday, Chief Justice Poitras said no stone was left unturned to make sure that maximum Mohawk citizens were made aware. And by memory, there was workshops on the territory, off the territory, one or two public meetings. There was also a discussion on do we need a double majority or a simple majority. Pros and cons went. The fact that that agreement was without prejudice to any other grievances the Mohawks may have, and the fact that you were not giving anything away, no rights, no nothing, so a simple majority. There was a vote, and as you were mentioning earlier, 239 to 237, 10 spoiled ballots. The council wasn't comfortable with a two-vote majority, and I'll pass you the comment how the satisfaction of the minister to enact legislation on a document where there's only two vote differences. So the council retained the service of former Chief Justice Laurence Poitras, who had also been the chair of the Poitras Commission. If you remember, he sort of named the SQ for their less than honorable practices, and he was one of the 3 judges who got Marshall liberated after he had spent 10 years in jail. Council speak on that is this person is independent. And he carried out, put out a report, which council provided us a copy, and I think a communique went out to the people. The agreement had been initialed here on the territory on June 21st, 2000, on Aboriginal Day. Minister came, went all around the place, and all that was getting done there is to initial the agreement. That satisfied Canada, but Ganatasaki had to do its process to get the membership to hold on. Once that get done, and the LGA, Canada commits that when the agreement is ratified by the population, confirmed by the BCR, we will enact legislation. So we couldn't start legislation until the agreement was signed, and Canada introduced legislation. As I mentioned earlier on the other issues, we got all sorts of comments, all sorts of letters who came to us, came to the federal chief negotiator, the minister, and the prime minister. And the argument being made is all this got done behind closed door. Nobody's aware except the council and Canada, which was not the case. The importance of that milestone in the negotiation was important for council and important for Canada. You got a 9124 status without being in the Indian Reserve and without prejudice to all your other claims, built in the LGA. And with a lot of insistence by your negotiating team and your lawyer, they wanted that in the legislation, it was made very clear that the lands were 9124, and also confirming it was not an Indian reserve. If you look at our drafters, they say, well, come on, that's it, that's all. Council asked, and after consultation with Justice, they wanted their lawyers to sit down with those drafting the legislation to provide input. And the message that was conveyed, you have to stick as much as possible. What you put in the legislation is in the LGA. And what the Ganatasaki Interim Land-Based Governance Act does, it's an implementing legislation. You've made a deal, you've signed off, you want a special status, you need legislation. Legislation was introduced. Many people have asked, why is it called S24 and not C24? Is since there was no actual dollars implied for the legislation, and the fact we were coming to the end of the session of the House of Commons and the Senate. So starting with the Senate, you're saving yourself a lot of time, because when it gets introduced to the House, all the parliamentarians, when they see yes, it's okay, this has gone through the Senate. What the Senate was interested, especially on the 2-vote majority. They say we have to invite people that are in favor, and we have to hear people who are against. And since the 57 lots in the village, it would be good, it wasn't an obligation, it would be good if someone from the municipality came and addressed us. You know the relation with the municipality, coming up and supporting a piece of legislation that's going to make Mohawk lots in the village. A lot of talking had to happen. People who showed up in favor was the Grand Chief and members of his negotiating team. Naturally, Canada, it's our bill, were in favor. And Matt Patry showed up, said he was in favor. And then Helen Gabriel showed up. Pearl Bounsfield and Bertha showed up. And with Helen, I always have trouble with the name that the gentleman accompanied her. I think John Denny or John Cree.
John Cree.
Yeah. And they came up, they voiced their concern. Helen said what she usually says, the band council is a puppet government and people are not aware, it's done behind closed door, and you may be setting yourself up for another 1990. Pearl and Bertha basically said the same thing, putting the focus that it was done behind closed door. Matt Patry, to everybody's surprise, said, well, you know, 1990 happened, the Mohawks have legitimate, took a few shots at the government of Canada, that's right, but overall, he supported the agreement. It was tabled at the Standing Committee of Aboriginal Affairs of the Senate. On that committee, there's four Aboriginal people. The president was Senator Shalifu, First Nation from out west. Charlie Watt, Inuit, who, when I was up north, was my hunting buddy.
Charlie Watts?
Charlie Watt, Senator Watt did it.
Okay, I was thinking the drummer for the Rolling Stones.
No, Charlie's the guy who, when he was president of the GUIA, who negotiated the James Bay and Northern Quebec Agreement. He got appointed to the Senate. Johnny Adams, who's also a Inuit from Ungava Bay area. And Olivier Gill, former chief of Mastouyuash and former director general at the Quebec region. And the committee accepted, was sent back to the House of Commons. And there again, committee meeting, people were called in. Same people were called in, except Matt Patry. And the result was legislation was passed. Once you've passed the legislation, for legislation to be in effect, you need royal assent. It came back to the Senate on the last day. Senate was sitting. And we find out that the Governor General is going to be attending and will be chairing. So we're all happy and so forth. And it's not the big process we thought. Once the legislation is read in French and in English, all the Governor General says is end of story. So it got royal assent June 14, 2001, on the last sitting of the Senate. There's piles of letters and phone calls that we got criticizing the process, criticizing the agreement. You guys did that to declare Mohawk Territory a municipality, and in hindsight, everybody has a 2020 vision. Canada never wanted to make this territory a municipality, and even if it wanted, they could not. Only the province has that jurisdiction. The sad part is all that hard work was done on both sides, and today, I explained earlier the harmonization agreement. Some work was done on that. It remains unfinished. The importance of the compatibility agreement is in the agreement and the act. It says, and it's limited not to what some people think all Mohawk lands. No, it's limited to the 57 lots in the village, where your laws and bylaws have to be compatible with the municipality, the same for them. And you put the last version in the compatibility agreement
I
in the
did,
line?
yes, the last version that was created.
There was lots of discussions. Mohawk Council, Municipal Council, and to cut off the perception of politics that the Mohawk go and do business at the municipal office, or the municipality does business on Mohawk territory. It was agreed that the lawyers would do the talking. And what I brought is the final version you saw didn't come up. There was a 5 or 6 version, and I will give you, and your lawyer probably has the same thing, is how evolved the various versions. What the lawyers were committed to is on the last version. Lawyer hasn't got the last say, neither for Ganatasaki, neither the municipality. And the lawyer for the municipality had a weird name. His name was Maître Paul Hus. And
Okay.
at the end of the last version, the lawyer for the municipality committed to, I will recommend to my client that this is a good deal. And your lawyer said, I will recommend to my client this is a good deal. I think you know the rest. New government attack, and it died. And that's that. So I'll,
Just an aside there, Walter, I'll be cataloging and
And-
making copies.
to those who think that the LGA was signed behind closed doors, both parties felt this was an important first step to continue the negotiation. So,
That was, you're talking about when they signed the LGA on Aboriginal Day,
no, they initialed the
they
agreement.
initialed the agreement.
Once you had your ratification process, the minister and the Grand Chief,
Yeah.
by way of resolution, was authorized to sign on behalf. They had to sign the agreement so that minister, I shouldn't say minister, Canada had to introduce legislation. The minister felt it was important. He wanted that, and the big the big room on Parliament Hill. By respect, he wanted a Canada flag, he wanted a Mohawk flag. You didn't have a flag, so creative people on your end made a big plaque with what was the Mohawk cross at the time, and that's what we're going to put in the House of Commons.
The Mohawk Cross?
Yeah, you'll see a picture, no,
Oh, the
the
wampum
Mohawk
belt.
crest, no, it's
It
this.
was the angry
Oh, that, the
Indian logo,
alien.
angry Indian
Angry
logo.
Yeah.
When you want to put flag on Parliament Hill, Canadian flag, not an issue. The provincial flag or territory flags, not an issue. The rest is an issue. So with that plaque, we said it's not a flag. But for the minister of the day, what was important is that it was a balanced negotiation by the parties. There was a lot of people in attendance, a lot of media, got good coverage. It was a positive spin. So when people say it was done behind a closed door in a sneaky way, I object to that. So these are the negotiating teams of both parties, and the rest is the signing ceremony, communication, interviews with the press. And there's a shot there, you see that there's people in the room. So anybody who wants to say it was done behind closed door, not the case.
Mhm.
So, two other things I want to touch on. In negotiation with the various councils over the years, some of the items were included in the framework agenda or the MOU. And any negotiation we did before we started, we made sure that we could tie it to the items to be negotiated in 91 and in 94.
Mhm.
And one day, early in my negotiation years, Mr. Pelletier was Grand Chief. He wanted a meeting in Mirabel to say welcome to Mohawk territory. He brought in somebody from the McCord Museum with the two-dog wampum. Explain, talk, he wanted everybody to understand. Council come and go. One council asked us, how can we recuperate the wampum? There was preliminary discussions that since it's an historical piece, it's gotta be kept in a place, such temperature, ta-ta, and ta-ta. And everybody around the table, mainly the Mohawk side, were trying to figure out how the hell did McCord get the wampum? So we had the students who were, I forget if they were archaeologists or historians. We asked that they do a research, mainly on the Truro wampum, how they got it, and other wampums. The intention was, as the negotiation unfolded, we would go, we mean the feds, we would go sit down with Heritage Canada, table the demand and say, well, how do we go about having that wampum belt reverted to Gamatasaki? Council come and go, did not become a priority. I leave behind the research, appreciate it was done by students, but they identified for a number of wampums across the country, and they also pointed out the difference the different interpretations that Canada did, the First Nation did, and other people. So it's yours, and it never got off the ground because other priorities came up.
Is it still open to get repossession of the belt?
I couldn't tell you. At the time, Serge, we had a lot of flexibility. And as I said earlier, we were tying these things to the agenda and process of the MOU. We had special cabinet authority, we had special treasury board authority, and the last authority died in March 2007. So as we speak, I don't know where that is and how it gets done. In the LGA, as well as S24, Council has the power to regulate and legislate on a number of issues, including fire protection. This was brought up at policing and justice table because they say, well, policing is more than policing, it's policing and public security.
Actually,
The next item, it's an information for council. In the LGA and the legislation, one of the powers you're given is fire protection and public security. The council of the day wanted its own fire brigade. At the time, these services was provided by voluntary fire brigade from the municipality of Oka, where at one point in time there were Mohawks who were part of that group. Since we were progressing, council now has powers to regulate, to legislate. They have the responsibility for fire protection. They want a fire station. Fine. Sit down with our people at the office. You may remember Dave Bender and company. They say, okay, well, there's you have to get a study made by this firm, and that's the only firm authorized in Quebec to put out an opinion if you can have your own fire brigade, and as opposed to voluntary service from the municipality. Fine, told that to council, said get a quote how much this is going to cost, and we'll pick up together. There was a number of preliminary report, and when they had looked at the territory, for unknown reasons, they never went and asked Saint-Sophie. So when they did their little circle, at the time that was, they can deal with the voluntary fire brigade. But when they did the circle, using the two lots in Saint-Sophie, which are Mohawk lands, it became, the opinion says, yeah, okay, they're entitled to their own fire brigade. So we went about of how big does it have to be, what kind of equipment, and so forth. At the time, Claude Vermette, who was the public work fellow, he was municipal council in a place called, not too far from Bellefeuille. And we looked at the community, comparable, so the Grand Chief, the chief responsible for public security, myself and Claude went to see how they were set up, what they had in terms of equipment. Very well received, photo session, signing of the Book of Honor and so forth, offered cooperation and so forth. Came back, and what we then needed is, how much is this going to cost? It got costed. Then our problem was, where and how do we get the money? It was evaluated at the time 1.1 million. We were prepared to have our infrastructure people put money. We were prepared to put money in negotiations. At the same time, we were negotiating the possible appointment of Justice of the Peace. I haven't got that file with me now, but I'll mail it. We got together lawyers from Justice Canada, lawyers from Justice Quebec, lawyers from Mohawk Council, Mohawk Negotiator, Canada Negotiators, and since the Act gave you power to appoint justices of the peace, and since you're not an Indian reserve, people looked at how Kahnawake appointed their justices of the peace. People looked at how Akwesasne did it. So, free-flowing discussion, people came with the conclusion it was sort of a hybrid, and a curriculum had to be prepared. An outside lawyer was also brought in with everybody's consent, and we started to work on a curriculum. Also, criteria had to be developed, type of qualifications a justice of the peace would have, powers and so forth. We were going to use any leftover money because you have laws, you have a police force, you now have a justice of the peace. And the thinking was violations of Mohawk law that happen on the territory, people get arrested by Mohawk police, they're tried by a Mohawk justice of the peace, which all made sense. So at the same time, we're working on the curriculum, working on the criteria for selection, and I think we collectively thought that if there was leftover money, since the police station would be here, fire station would be there, we would put a little annex, which would be sort of chambers for the Justice of the Peace to hear cases. As I've mentioned before, comes another council, and on this particular issue, there was a sunset clause on the dollars. It's got to be spent no later than March 31st. New council came in, we did the transition, did the briefing, and the Lieutenant Council says, this is not a priority for us anymore. We should invest that money somewhere else. We said the money is targeted for that. March 31st came and gone. Never happened. What I'll leave behind is the exchange of correspondence and the two studies that were made. Sad story, but we said we'd tell the things as they were and how they happened. And all these exercises we're doing was putting into place the authorities and the lawmaking power that you ask for and you got.
Mhm.
Because you have to walk the talk. Once you say, this is good, you have to put things in motion.
Mhm.
The negotiation with the new council did resume. And we sat down and sort of explained the process. The regretted Crawford was appointed Chief Mohawk negotiator. Robert Mainville became the new lawyer. Robert Mainville, for those who knew him, is now a Chief Justice in Quebec and is targeted, I think, to be one of the candidates for the Supreme Court. He came on board. We did a factual briefing like this. We also made Crawford and the negotiating team aware that we have a challenge here. We've negotiated all these agreements in good faith. And council had put out a communique, the new council saying no PMA, no LGA, no S24. So we explained and we said, you know, we don't think we're getting a positive message. We've just negotiated all these agreements. Your requests, without prejudice, you haven't lost anything. You got the status you want and you don't have an Indian reserve. So to tell us that the new council will reject what the previous council did, the message you're sending us is you make a deal with the Mohawk Council, you're not sure that the following council will respect it. Then we agreed that there'd be more in-depth briefing sessions. It was agreed that it would be Crawford on your side with Mike Mainville. At our side, it would be Chief Federal Negotiator and myself. Good, constructive discussions. We ask that share with us the problems you have with that, and we'll try to explain. Unfortunately, the second session, Crawford had a heart attack. We got him out of the room and to the hospital as fast as possible. I think he died the day after or 2 days after. A deadlock on council. 3 wanting to go one way, 3 wanting to go the other way. You may not like what I'm going to say, Serge, but it's factual. We get a resolution, we get a resolution and a letter saying that before Crawford passed away, he designated, I think it's Steve Bonsfield as chief negotiator. We send a letter and send our regrets that Crawford was a hard negotiator, but as the tradition has it in your council, it was all over, hey Walter, not personal. And we asked council to send us a BCR signed by the quorum of chiefs, appointing a chief Mohawk negotiator, which had been the practice since the beginning, and it never happened. Nothing much happened because you didn't have the chief Mohawk negotiator. Somewhere in there you ended up in third-party management.
Yeah.
That's another issue. And finally, I'd say a year or so later, there was a by-election. James's group now had the majority. Then some talks and some negotiation occurred. Then there was another election. A new Grand Chief was elected, and there was I'll be very polite, differences of views and point of views and political positioning from some of the chiefs and the Grand Chief.
Mhm.
And then it was in the last year of Steve mandate that the Canada gave its reply to the allegations submitted in 206. Specific claims that took over, that's handled by Ottawa, not us, and I just remain sort as, when we're unhappy, who do we go dump on? The best person is Walter, and so I sort of try to coordinate things that various councils wanted over the years. We did give the specific claim people a briefing on the history of negotiation, and the rest you probably know more than me.
Mm. Yeah.
That's it for me. If there's questions,
Well, during my time, especially with the first mandate that I had, I hope I didn't bother you too much with the issues.
so I paid for that.
Yeah, well,
You did it in a severe
It was
way,
not-
but in a nice way.
okay, anyways, during that time, I always figured, and this I still believe, that when I start seeing that a council is not working for the best interest of the community, that's where things, like here in this council, we've had our differences, but I never doubted that everybody at that table was not working in their own
I
way
agree.
for the betterment of the community. It's just that we have difference of opinion how we're going to do that. Whereas the other council, it was very clear that it was not for the betterment of the community, it was for betterment of their own agenda, the agenda being where they wanted control. They wanted to control everything. And this idea of quorum is something I think that needs to be addressed as soon as possible through consultation with the community to find out what the community says. If it's a quorum, fine. Is it a quorum that must always include the Grand Chief? Or do they want to go closer to consensus? That needs to be clarified. As Grand Chief myself, I dance on one foot to the next.
Good
People-
politician.
Well, try, but the issues are that there's no roles and responsibilities that are clarified anywhere. There's no policies really that tell us as chief, as Grand Chief, this is my power, this is my authority, and then this is the council, and so on. So there's nothing. And that's why we've had all these problems that you've seen over the years, because that's never been clear. They say custom, custom, custom. Okay, well, explain to me custom. I go to this person, it's one thing. I go to that person, it's another. I go to that one, it's another. So it's gonna be a challenge just to get that clarified once and for all. Okay, so I got people in the community back in that first mandate who were saying, I don't care if they're quorum, they're not allowed, they cannot overstep the Grand Chief. He's the Grand Chief, he's elected separately. He has a different authority, but that's not clarified. That's what makes it extremely difficult. So I'm hoping that in the coming remainder, the remaining months in this mandate, we'll be able to push something through to the community that's clear and no ambiguity, and let the people decide. Give them a choice, okay? Is it this, or this? And then we'll narrow it down, boil it down to, here's the custom once and for all. That'll change a lot of things.
I seem to recall, and maybe I'm wrong, I think council has asked and has received funding to modify your election code.
Yep. Yeah.
So that's our contribution to help. See, there's two ways to elect band councils. those who have custom codes, which is your case, where our role is limited, you inform us and you say, this is our code, this is the election result, so and so is chief or grand chief. The other way to hold elections is using Section 74 of the Indian Act, where the department plays a big role.
Yes.
And most of the bands prefer custom codes. There are bands where we sometimes have difficulties. They're comfortable with the elections being held under Section 74.
Mm-hmm. Yeah. No, I understand. But like I mentioned to you yesterday, we had a serious problem in the last mandate. Okay, it was brought up at a public meeting. Again, I was consulting the community, letting them know what my problems were. What do you want me to do about it? Eventually, an elder stood up and said, okay, I'm proposing a non-confidence vote against the entire council. And then it was seconded. Then I asked, okay, is there a vote in the community for this proposal? And the majority said, yes, we want to have a non-confidence. So it took me some months to organize that because I had the four at council blocking me. I didn't have access to funding. I didn't have access to any resources whatsoever. So we had to organize this pretty quickly with what little means we had. Once the decision was made by the people, which was overwhelming, the four that were in council were rejected by as high as 94% to kick them out. But they ignored it.
What was the size of the people in attendance?
At the public meeting?
Yeah.
I'm not sure what the, do you remember?
Around 50, I think.
It was quite high. For a public meeting, we had quite an attendance that time. And that's where it triggered a process. They did not make the decision on the spot. They triggered a process. Anyway, the process was completely rejected by the four because they said, we didn't agree with this. You don't have to agree with it. The people told you you're going to submit to it. Like it says in the election code, the people are the final authority in all matters pertaining to their territory and their council and so on. So that's what was invoked. But they rejected it. And then Luc Dumont, who was the newly appointed director, RDG, well, he sends a letter. Once I sent him I sent Luc the results of the vote. It was just an FYI. I wasn't asking him for any recognition or anything. I just to let him know this took place and that's all. And he responded by, the first part of the letter was fine, that the federal government does not get mixed up in the internal affairs of Gunnesadauga. Perfect. But then when he said, we have no choice but to recognize the status quo of the 2000 election, well, that little clause there, he could have made his point without putting that in there. Now, the four, when they saw that, they went downstairs, they saw the email, and they went, wow, look at this. Indian Affairs still recognize us. I said, Indian Affairs didn't vote you in. So they went downstairs and they told all finance, they told all the staff, look, Indian Affairs, they still recognize us. You better do what we say, or you're gonna be in trouble. You're gonna regret it. I mean, it got to the point where I just found out, I think it was last year, that it went as far as being the staff in finance and all the other departments were told if they were seen talking to the Grand Chief during office hours, that they were going to be in deep trouble. So I always wondered when I went into finance, and all of a sudden the financial department, everyone was, they were stunned that I was there, and they were scared. I always wondered why. When we first came into office, Walter, Lorena went downstairs, and she went to talk to the staff, and the staff started talking about the previous mandate, about those four women that were there. Some of them broke down crying. I mean, to the point where they were suffering trauma by what they were put through. That's how bad it got. But in the end, the people did have their voice, like you said, and the report card came in, and it was a big fat F. Out the door you go. So, we, as a council so far, I don't think any council has ever moved in a more positive direction than this one. And I'll tell you, I still believe that this council is the best hope that Ganasadaga has with the remaining time we have to move some important stuff forward. You know, it still is the best hope. So, I don't know what's going to happen between now and the next election. Like even myself, I'm not quite sure I want to run again. It's a very difficult job. It's imposing on family and personally. And I don't know if I want to go through another, the next one would be 4 years. And so I got very little time to take care of things. But we'll make the best of the last 6 months of our mandate, see what happens.
To come back to Luke's letter, custom bands who hold their elections on custom codes, the only thing we do is we acknowledge the result of the election. If community members or elected officials are not happy the way things unfolding, their recourse is the courts.
Mm-hmm.
So Luke, whether it was your community or any other community, he has two options. He wrote what he wrote, or he quotes jurisprudence which rubs it in a bit more.
Mm-hmm.
So he sent the best letter he could with softer language as he could, but he has the responsibility to respect the Indian Act, where it says that bands under custom codes, their problem, not ours.
It should have ended there. That's it.
Yeah. But at our end, we have to do all sorts of transactions with the council, the funding agreements or that. We have to have a body in which we can send the contribution agreement and it comes back signed. If it comes back signed by one person, two less than a quorum, we can't move.
Mm-hmm.
So there's the political environment that you and council were in. At our end is we have to make sure that the community gets the service, and to have service you have to have money. To have money you have to have a contribution agreement or an amendment.
Mm-hmm.
And you have to have a recognized body. So with all these elements, the best we can do is I will recognize the outset of the 2000 or 2012 election. We have a body in place through which we can do business. Is it the preferred option? There's no option. That's the only one on the table. And I think both yourself and your council and us at Luke's level, you have to make sure that up and above the political debates, community have access to services. So we're stuck in that. If you want to change the rules of the game,
Mm-hmm.
you modify your code accordingly.
No, the code was very clear that the people are the final authority in all matters pertaining to their territory and their council. It's already in the code. Okay, regardless of legal precedent, the people had made a choice. The quorum was now 2 out of 3. We were 3 chiefs that were given the mandate back. The others, their mandates were removed, so the quorum now was for 2 out of 3. That's what the whole issue is about at the time. If you want to go by quorum, fine. This is the new quorum now, and that's what we made clear. We sent to Luc, I believe at the time, was it the minister? Anyway, sent it to one of them. But to make that clear, that the people had made their choice. And Ottawa supplanted the choice of the people. It was in our election code that you guys recognized, and we pointed that out. And yet you still held to Luc Dumont's letter that said, recognizing the status quo. They had no right to say that. The status quo no longer existed at that time. It was rejected by the community. They said, no.
I see your point
So-
about having right, but on the other hand, he has obligations. And he's in a, not a win-win situation, he's in a lose-lose situation. And
This was not removing his responsibility. He would still have had the obligations he had. He could have still respected them, like I said, because the quorum had now changed to 2. The people had made the choice, and they could have safely have gone with the election code, say to the government, no, look, their election code says this, and this is what they did. They made the choice, and now the quorum is now 2. So they could have safely said, okay, for the time being, Ottawa can still justify transferring the payments under this new quorum until an election was called. But nobody even thought of thinking just a little bit, just a little bit harder to find that justification like you did. You know, all this, what did you call it there? This original thinking, this creative thinking. Oh, should have used it.
creative thinking was on both sides.
Yeah, well, we did ours, your
But
side.
as you said, at the end of the day, there was an election and things like that.
Yeah.
But if you go back to the time of Jimmy and so on, when they were 3-3,
3-3.
there was BCR stating quorum 2.
Mhm.
Yeah,
But it's still,
if I recall, in that period, things were different because you were under third-party management. Different ballgame. Different ballgame. Is you're on third-party management, the contribution agreement
The food's here?
is dealt with the third-party manager. Sorry. Where that had a positive effect is you were in a number of legal battles,
I don't
and
think so.
the money couldn't be seized because it was in the hands of
No,
third-party
but
managers.
what I'm talking about, that was before they went into party management, because there was at the time there were 3-3, well, early 2000, maybe 2002, and I think they end up in third party 2003, and on April 1st, 2006, we end up under co-management.
I'll bring you back. When the council came 3-3, the spending was more than the budget. We had the preoccupation that essential services were at risk. I was at the meeting when André Courtier called in the 6 chiefs, to inform them how this would unfold and to give them the letter that said you were on third-party manager and who was the third-party manager. Only 3 chiefs showed up. It was, I think, James, Mary, and I forget who else. Clarence, yeah. So it was during that period that the third-party manager was stuck. And spending is high. Spending is higher than what's coming in. Essential services are at risk.
No?
Okay.
Thank you.
So I just wanted to complete the film, Walter, and I did have a final question, if I may.
Go ahead.
I wanted to ask, what is the process of repealing a legislation? And what is the ramification to Gunnesudoga if that is what we wanted to do with the LGA?
That's the $2 million question. I'll start with the second part of the question. Is, as we saw during the presentation, I laid out what Ganatasaki got in the land governance agreement, which was put into force with the legislation. Doing away with the legislation would have this. No more 9124 status, because it's the agreement and the legislation who gave you the status of the land that was wanted without being an Indian reserve. All the powers you have to regulate and legislate, which I listed out early this morning, they're not there anymore. The possibility to appoint justices of the peace is not there anymore. The most difficult question is the status of the land. If they're not 9124 lands, they're what?
Mhm.
A couple of options, and I'm not a lawyer, but you may want to check with your lawyer,
Mhm.
is the chance that Canada would accept that these lands become 91A lands, federal public land, would be extremely difficult, especially in the context that we were asked and we agreed to give a 9124 status and not make it an Indian reserve. I'm not Prime Minister yet, I'm not Minister yet, but it would be a very uphill battle. You remember the Jean-Luc Simon case,
Mhm.
where the Court of Appeals said, no jurisdiction vacuum. The questions you now have to ask is, I got no lawmaking power anymore, no regulation making power anymore. And the court has said, at least on the Jean-Luc Simon law, failure from Canada or the Mohawks of exercising jurisdiction, the municipal bylaws apply. And the minute the word would get out there that there are no more 9124 lands, it will beg the municipality to say, okay, we'll use the Jean-Luc Simon case, we already got a judgment in our favor, we'll re-argue the absence of jurisdiction and we'll apply it to the others. Another difficulty, and that I'll have to check with our finance people, is the fact that these are Mohawk lands. You don't pay tax, we pay Allieu tax. The fact that they would become lands that are neither 9118 or 9124, I doubt we would have the authority to pay Allieu tax. That would mean the municipality has a loss of revenue. He has two options. He bills the people or he doesn't provide the service. How do you go about? I know what it took to get legislation is a very difficult process. I imagine it's as difficult to repeal the legislation. I had checked the Canada Repeal Act.
Yeah, in fact, I had mentioned if that was a possibility
Yeah,
of,
so-
in fact, using that legislation.
I read the act and sat down with our lawyers. The only time that can be used is if legislation has been enacted and for all sorts of reasons, for 10 years, the legislation has not been put into place. Then you use the act to have that rescinded. Which would not apply in your case because it got royal assent and
Yeah.
steps were. The arguments that would have to be made by the council, you saw what it took to have the land governance agreement ratified. It's fair to assume that if you're going to undo it, and if it was possible and acceptable, you would have to go back to the community and get a vote on it.
Mm-hmm.
This is my opinion, based on my knowledge. I would strongly recommend, if you want to go that route, go sit down with your lawyer who will say, Walter is right, oh, I'm on camera, or Walter is not there.
Okay. The other way, I think, would be if it were a legal challenge, maybe to bring this before the courts, if the courts strike it down. That would be another way.
Yeah.
Now, that's
You-
where,
You have the burden of the proof
absolutely.
to demonstrate that this has ill effect on the community. When
Mhm.
the initiative was taken by the Ganatasaki governor,
Mm.
we did due diligence. We had a ratification process, which you were responsible for. The result was tight. And keep in mind the former Chief Justice Poitras's report, where he said that this was an excellent process. No stone were left unturned.
Mhm.
He did the recount and came to the same possibility. But your best advice on that would be from your lawyers.
I understand all that. There's other things that I've been looking at over the last 5 years whenever I had time. I explained to you the idea of the trust. I had a legal opinion on that from 1983. Since then, we've also had the Haida, Delgamuk, we've had the most important one, Chilcotin. And we have the historical arguments of our community. You have the Corinth case. There's the ordinance of 1833, which I still got to dig up and look at. There are pieces in the ordinance of 1833 that point to a trust. There's that old saying that says if it walks like a duck, it quacks like a duck, it's a duck. And now, that goes the same with the LGA. You say the federal government has no power to create a municipality.
Exactly.
But if the legislation on the whole put together, if it looks like a municipality, it smells like a municipality,
No?
you know. But that's, I'm just playing devil's advocate because I've heard that argument before. I don't believe that's the case, but there are
Definitely not.
things that point to maybe something like the harmonization we discussed a while ago, which is the biggest problem, which points to another judicial. Now, if you're going to change custom, you have to get that double majority. And I remember some arguments saying that they did not get a double majority for implementing S-24.
That's correct, and what I explained this morning.
Yes.
We sat down, both sides discussed it and said, what kind
Yeah.
of majority do we need? And the fact that Ganatasaki was getting everything they were asking, it was without prejudice to any other claims you may want, and no concession whatsoever.
Well,
So a double majority was not.
Well, I only mentioned it because to change the custom of a ban,
Yeah,
you must get a double majority. Did S-24 change the custom of a ban? It made some amendments to it. You look at the harmonization, it was never the custom of this ban to harmonize with the Oka Village, and that could be interpreted as right there a violation of a Supreme Court decision. I think it was in the Davis case that,
yeah, but the difference, Sal, with all due respect, is
yeah,
what we did was at your request, the government of the day,
mhm,
with BCR saying this is what we want.
yeah,
So we did, from my perspective, due diligence. We said, fine. Even though you're not giving anything away, we still like our ratification
Mhm.
process.
Yep.
We could have also said, fine, nothing has been given away, it's without prejudice, they're not losing nothing, let's just take a VCR. Both the council of the day and us felt that you had to go out there and check the waters.
I understand. There are several things, like I said, I've been researching over the years that point into a different direction that was never explored.
Mhm.
And the Privy Council made it clear that the lordships at that time, in their decision, they say, well, they looked at the seigneury of the Lake of Two Mountains and they said, it's obvious to the Privy Council that we're dealing with some form of trust. So that was their decision, but they left the case wide open so that we could go into a different legal process outside the Privy Council. As far as I know, that was never done since 1912. There have been attempts, but nothing really to say that we challenged the Privy Council's decision at the time. There's a lot of details there related. Yeah.
At the time, that was the highest court in the land, there wasn't,
Yep,
there
but-
wasn't a Supreme Court.
Yes, but it wasn't a handed-down final decision from the Privy Council. They left the door open for other litigation. And that's where I'm coming at right now, is that although so much time has passed since 1912, I think the basis for the argument of the trust, I think we should look at it a little bit closer to see whether this fits into that. Because the trustee-beneficiary relationship between the Government of Canada and us, well, we have to look at what does that really mean. Because there's a lot pointing towards, there's a lot of historical evidence that points to it, and everyone's ignored it in the past, 125 years?
Including the Mohawks. With
Exactly
due
right, that's what I mean.
respect, all the negotiations I've been involved with, including the filing of the legal allegations by counsel and their lawyer, and I'll double check, I have never heard the 1833 ordinance.
Mm-hmm.
It has not been alleged as a breach, and neither was the relationship and trustee. The first time that came up to my attention is when you brought it up.
Mm-hmm.
And it's not up to me to give you advice, I'll give you facts. It becomes difficult to go to court and say, they didn't do this, they didn't do that, when in your allegations it was never brought up.
That's not my problem, that's not my fault. I'm bringing it up now, but
No, but it's not ours.
within the
We-
claim, yeah.
We reacted to the allegations put
Mhm.
forward. We recognize responsibility for a number of things.
Mhm.
We explained which one, and we based ourselves on the legal document that was stable, and
Mhm.
it was never tabled as being an issue until you recently brought it up.
Well, there's been some detail, like I said, evidence. You look at the Sulpicians and the relationship with us, how they acted. Okay, they had an obligation to educate, Christianize, provide us with the necessary benefits of the land. Wood cutting, fishing, gathering, there were several things like that.
Pasturing,
Pasturing, so they acted in the capacity, if you look at it, as a trustee, providing the, if they had the title, outright title, they could have said, okay, all of you, get out of here, it's our land now. But they didn't. What they did was they continued on with the responsibilities detailed in the original grant, and later on, accepted after the capitulation of Montreal, they accepted the same type of responsibility that went on. Okay, that's really important, because in 1945, when the federal government allegedly bought the remaining lands for $1. Okay, that dollar is only symbolic. You didn't pay fair market value for the land, so you can't call it a land transaction. It was a simple transfer of trusteeship from the Sulpicians to the federal government. But again, like explained yesterday, in trust law, you can be an executor and a beneficiary, but you can't be a trustee and a beneficiary. But in this case, the federal government is all three. It's the executor, the trustee, and also a beneficiary, because it's making money off our lands that were guaranteed to us under that original trust, and the benefits that derive from it. Now the federal government is occupying all three, which you look at any trust, that is illegal. You cannot do that. So what do we do in this case? If this is what the Privy Council said, and the ordinance of 1833, even Joseph Swan brought it right to the face of the Sulpicians, you have breached the trust, and we want you replaced, we want you gone. So, look at the Sulpicians and what they had done at that point. And
In the current decision, the question being asked to the Privy Council of London was, do the Sulpician have title to the seigneury?
mhm,
It was ruled that they did have title.
with responsibilities. They had obligations under that title. If they could not fulfill those obligations, it was clear that the lands reverted back to the crown. The Sulpicians couldn't carry anything with them. And that meant if they could no longer Christianize us, they could no longer educate us, they could no longer provide us with the necessities of life, which they clearly did not. Only a few Algonquins stayed with the Catholic Church. The majority moved away, and the Protestants took over. So, what happened? They could not fulfill their obligations under that grant.
Mhm.
So that was the whole
So,
point.
Was any of this, and I'd have to go back to Corinth, was any of this argued in the Corinth case? And I haven't seen it, but my
No.
mold and my memory's gone weak. I don't recall having read in the judgment that argument, and I don't recall reference being made to the 1833 ordinance.
Mhm.
And as of yet, when you table the allegations that alleging the wrongdoing from Canada and not respecting its obligation, it was never put forward, Judge.
It might be
I
subject to
may
a
be
different...
I may be saying things that you don't like, and
No,
I
no.
respect that. I'm giving you my best shot on the information available.
Of course, and
I
I'm giving you
just have
mine.
something to interject. Up until what year were natives denied legal representation?
You'd have to check that one with your-
1942,
1942.
Were denied what?
legal
Legal
representation.
representation, it was illegal.
Under the
So
Indian Act,
You're
yeah.
looking at cases that happened prior to that. So how could our rights be represented properly if we were denied legal representation?
Mhm.
Well, okay, Serge is arguing the Corinth case. That happened in 1912.
That's still prior to legal representation.
Yeah, what she's getting at,
Well, you were getting legal representation because your lawyers of the day argued that case in front of the highest court of the land. So
Mhm.
to say we were not entitled to legal representation when you had lawyers argue your case in 1912.
mhm. I think that goes back again to the ordinance of 1833. It's quite possible that we were exempt from that because we weren't a reservation under the Indian Act. And under the Indian Act says that any lawyer giving legal advice to any Indian was subject to getting disbarred or even imprisoned. But we never fell under that. We were under, that's why I keep arguing this. What were we under exactly? We always said it was our land. Our chiefs from way back from the beginning said, this is our land. And the Sulpicians are only here to help us. They're gonna help us educate our children, Christianize, and so on. Okay? That's what their function was. That's what our belief was, that this is what their obligations are to us. Now, the Crown itself was dealing with all its other stuff, you know, dealing with its Indian Act bans and their treaties and so on. With us, it was completely different. We fell under the Treaty of Oswegatchie of 1760. Clearly, we had protection under that. But we never accepted or could not go under reservation. If you remember, what's his name, Sir William Johnston, when he first approached the Iroquois, he said, we're not here to displace you. You can keep your lands, you can continue the peaceful occupation of the lands you're on, you can keep your hunting grounds, and you can keep your priests if you want. That's what he said. Some, like us, we said, we'll keep our priests. We have a pretty good deal. Up to that point, we had a good relationship with them. It was only after the English took over that they started acting like the way they did, stealing the lands, hacking it up, and enriching themselves with the benefits. And that's where I think, that's where the breach specifically for Kanesatake, it doesn't apply to any other place in this country. That's why we are so special or original within the laws of Canada. Because of that different relationship. There's treaty, Sulpicians, the Crown, and there's all these little dots that you start putting together. Eventually a type of picture starts to emerge. Now, they say the Sulpicians have title. I'm saying we have underlying title. If they could not fulfill.
So we're not
No.
saying that the Sulpician has had title. It's the highest court of the land who said that. And the argument the court was asked to rule on at the request of the Mohawks of the day.
Yes.
Do the Sulpician have title to the land?
Mm-hmm.
And the court, I mean, none of us were sitting on that court, said the title belongs to the seigneur.
Yes, with specific
Good argument.
obligations.
Yeah, but they still had the title.
They had the title so long as they met their obligations. That's what the ordinance of the 1833, according to Peter Hutchins' opinion, points to. And if they can't fulfill those obligations, and it goes back to the Crown, the executor, another trustee is appointed, but in this case, the Crown appointed itself as the trustee. That's,
I
check it out.
don't
please.
remember having
Just-
read the ordinance, but the important point is, and I appreciate we're having the discussion, at no point in time, including in the Corin case, or the allegations you tabled in 206, was that mentioned. You cannot be guilty of something nobody brought up to you. And if it goes back, if the argument of your case lies on an ordinance of 1833,
No,
well,
some of it does.
okay, and Corank happened in 1912, that was never brought up. The acceptance of your claim came in, you table in 206, we acknowledge in 208, and none of that was ever brought up as a breach of Canada.
Well, that's, I wasn't there at the time, so.
Neither was I.
But
Had
2000
we been there at the time in 1912, we would have found a way to resolve that.
I don't know, but I'm talking 2006,
Yeah.
when they did this. Obviously, somebody did not do the proper research, because if you establish that it is indeed a trust, and you guys are the trustee, then having this here might not even be necessary or legal for that matter.
But for sake of argument, and this is a worthwhile conversation, is the legal firm who tabled the 206 allegation is Peter Hutchins' firm.
Mhm.
And if he was aware of the 1833 ordinance, I imagined before the allegations were tabled, he's the senior lawyer of the firm. I have to assume, and I can be wrong, I have to assume that he read the allegation and gave it its okay.
2006, I don't think it was him, I think it was Steve Bonspiel at the time. Not Steve Bonspiel,
Dave Schultz.
Dave Schultz,
No,
yeah,
and-
Angeli Choksky.
Yeah, but both of them were part of Hutchins' firm, where
Mhm.
he's the senior, no, he's.
In 2006? No.
Yeah, yeah.
No, they'd already gone on their separate ways. In 2006, Choksky wasn't working for Schultz
I
anymore.
think she was teaching.
Working for Hutchins, she was,
See,
She was what? She was working for Hutchins. I think Dave Schultz was working with another guy. Yeah, starting their firm.
I have to look back. I
yeah,
don't know who put the allegations forward in 2006.
it was Dave and Angela,
Mhm.
they wrote them. It took us 2 years to analyze it,
Mhm.
because I mean, there was lots of allegations there. We acknowledged some wrongdoing, and
Mhm.
that's why you're in a specific claim at
Mm,
this point.
don't
in
remind
time.
me.
That
But-
was
And
after
Angeli,
2009.
Angeli did leave the law firm, and you're right, John, to go teaching at Dawson
Dawson.
College. She wanted to have a breather and less stress. She
Mm.
was involved when some of the students got shot.
Yeah, oh, yeah,
Yeah.
yeah. That's right, but nonetheless, it doesn't make my allegation today any less valid. There's been some research I've been doing, and Peter Hutchins confirmed it with his legal opinion of 1983. Now, whether he used it or not, I know that when I started talking about the trust, that's why he sent me that opinion, because I was digging into it already, and he says, well, you might find this interesting. And I read through his entire opinion, and I thought, wow, you know, here's somebody, he's actually telling me I'm on the right track. Although he can't say it, but it's too late to bring it up. But he did recommend we bring it up to Fred Caron, bring it up to his attention. And I mentioned it to Fred at the negotiations, that what I want to see here is, I want to see benefits, future benefits of their trust lands. We're not giving those up. We did not dissolve the trust, and we want those benefits. You know, you pay us for loss of use, fine, but let's start talking future benefits.
And what was his answer?
He flipped out and he threatened to shut down the table. He did not like that, and I felt like at that time, I may have struck a nerve with him. And especially Doug Faulkner, who was his lawyer, Mr. Faulkner, said, well, if this is gonna be your attitude, then we're gonna fast track this to the tribunal. I was kind of taken by surprise, like, why would you go to that extreme? I just simply brought you another scenario that we might want to explore. And they hit the roof. So it told me again that I was on the right track, that there's something there that they know, and now that I've discovered it, they're, okay, it kind of changes the game a little bit, maybe. So,
That's his perception.
maybe.
I can't comment, I'm not at that table, but as far as I remember, this is new, and the trust is when you brought it up, I think, last year.
It's new, but it dates back to 1833. Even before that, you could go back to the original 1717 document on how that was formulated by the king, who was 8 years old at the time.
Yeah.
Anyway,
He had to go through a regent.
yeah, the regent, yeah, the, was it the
But
Marquis d'Orléans or something like that? Who was his uncle?
He wasn't related to me.
No. But still, the fact remains that there's a lot of evidence.
In the joint historical research,
Yeah.
where Kanetasaki and Canada agreed to the terms of research,
Mhm.
agreed on the researcher. When the preliminary report came out, your side of the table said, we would need more research here and there. We agreed to that.
Mm-hmm,
It got done.
yeah,
And the historical research was terminated in, I think in 2001. And it only got tabled in 2006. And I'm not gonna go through the political environment at the moment. And we responded in 2008, based on the historical research and the allegations put forward.
I understand. The research they did was of a historical nature, they
Yeah.
did some legal, but they did not go through every
They
single
talk-
detail.
They talk about all the way back when the move from Montreal to the Lake of Two Mountains, it goes, by memory, I think they go back to 1618.
Yeah. No, I think it's more higher, it's later than that.
Around in that area, they touch on the grant of 1717, they touch on the Régent, on the Conseil de la Marine,
Mhm.
and there was an instance where the military governor had authority to hear cases. 2 cases was brought to his attention on the same day. One was a First Nation person who sold his land to a non-native person.
Mhm.
Response was no. Then on the same day, and the history doesn't tell who went first, who went second, a Mohawk rented part of his land to a non-native. And the same military governor said, that's okay. The arguments put forward by your legal advisor was that at minimum, you had usufruct of the land. And that was one of the factors that was considered when Canada accepted the claim. And it's been ongoing since.
Mm.
We may both want to read all these documents. I mean, the joint historical study is.
I know, it's big.
And there's documents, some of them written in Old French, and you kind of goddamn figure out
I know.
what's meant. The measurements are not in feet, not in yards, not in meters, they're in reeds. And then the money value at the time that gets converted, so make sure you have a clear mind, no headache when you read the document.
Oh, believe me, I've read plenty, and yeah, it's really difficult to understand. But do you know what the basic principle is, why you create a trust? It's because creating a trust guarantees the succession of wealth from one generation to another. That was the basic principle of creating a trust. Now, when you look at this here, we're looking very clearly at some form of trust, like the Privy Council said. And we'd have to look at more details. I think research in France would have to take place to go look at the original intent of what the king and what his governing council had in mind at that time. Okay, so there's a lot of stuff that still needs to be dug up. We did the historical on this side, but we gotta do another research down there, see what they have in their archives.
And to the extent that I remember, the specific claim is without prejudice.
Yeah, yeah.
And nothing prevents you
Mhm.
from filing another claim.
Oh, absolutely, I know that, I know, but it was nice to have the discussion.
It's always challenging and interesting.